All right, let's get into this really fascinating legal story. It's about one homeowner who decided to take on his entire homeowners association. And it's a wild ride. You've got what looks like a clear-cut promise, a pretty blatant violation, and then a conclusion that almost nobody saw coming.
So we're actually going to start at the end of the story. Back in May of 2017, a homeowner named Kurt Gronlund had his whole case to protect his community's golf course completely dismissed. He lost. It was over.
And that's the big mystery we're going to unpack here. I mean, on paper, the rules that were supposed to protect that golf course looked absolutely airtight. So how in the world does a case like that just get thrown out of court? Let's dig in.
To really understand how he could lose, we have to rewind. We've got to go all the way back to the beginning, to the promises that were made in the community's founding documents. You know the rules everyone was counting on to protect them?
The heart of the whole argument comes from this one document called the REMA, and the language in it seems about as ironclad as you can get. It says the golf course property can be used solely and exclusively for golf or open space. That's it. Full stop. Seems pretty straightforward, right?
But here's the thing you got to remember. A rule is only as strong as the process you have to go through to change it. A weak rule could be undone with a simple vote by the HOA board, but in this case, the homeowners thought they had a much, much stronger shield.
And that protection was supposed to be a big deal. To change that golf course-only rule, it wasn't up to the board. No way. It required a supermajority vote from the actual homeowners. We're talking hundreds of residents who'd all have to agree to get rid of their community's biggest asset.
This was the magic number that gave all those homeowners that powerful sense of security. 2/3, a supermajority. That is a really high bar, and it was put there for a reason, to protect the most important part of their neighborhood. So the homeowners felt pretty safe. But that feeling of protection, well, it was about to be put to the test, and that's what led to this whole massive dispute. This is where the story really starts to go off the rails.
Okay, so let's walk through the timeline. In 2001, the promise is made official, written down in the REMA and the community CC&Rs, the big book of rules for the neighborhood. Fast forward 10 years to 2011. The HOA board, with a super narrow 3-2 vote, just amends the rules all by themselves. No homeowner vote at all. Then, in 2016, the HOA uses those exact amendments to back a plan to rezone the golf course for commercial development. And that right there is the final straw that led Mr. Gronlund to file his case in 2017.
So Mr. Gronlund has had enough, and he takes them to court. But what exactly was he asking the judge to do? Well, his demands were really specific, and they were all about hitting the undo button on what the board did.
He asked the judge for 3 basic things. First, he said, confirm that the 2/3 homeowner vote is absolutely required. Second, declare that the board's sneaky 2011 amendments are illegal and basically meaningless. And third, order the HOA to physically wipe those illegal changes from the official county records. It's all pretty logical, right? He's just trying to turn back the clock.
So, faced with this pretty clear argument, you'd think the HOA would have to defend their actions, but they didn't. They did something completely unexpected. They didn't argue the facts. They attacked the court itself. The entire fight really boiled down to this. Mr. Gronlund was over here shouting, "You broke our community's rules." But the HOA's defense was, basically, you can't sue us for that here. You're in the wrong courtroom. They didn't even try to debate whether they broke the rules. They just argued that this specific court had no power to do anything about it.
And that brings us to the one legal concept that this entire case hinged on. What in the world is jurisdiction? To put it simply, jurisdiction is just about authority. It means a court has the official, legal power to hear a certain type of case and make a judgment. Think of it like this. You wouldn't take a speeding ticket to a librarian and expect them to rule on it, right? Of course not. They don't have the authority. Every court has limits, and if you file your case in the wrong one, it can get tossed out, no matter how right you are. And that one concept, jurisdiction, is the key that unlocks this whole mystery. So let's look at the judge's actual reasoning to see exactly why this case got dismissed.
The answer is spelled out right here in the judge's decision. She didn't rule on whether the HOA was right or wrong. She only ruled on whether her court, this specific department, even had the power to decide in the first place.
And her decision came down to 2 critical reasons. First, the court's power was limited by state law to only rule on official community documents. And because of some very specific legal wording, the REMA, that all-important golf course document, didn't technically qualify. Second,
any ruling she made would end up affecting the rights of the person who owned the golf course, who was a third party, and her department just had no authority over them.
So get this, the judge never once said the HOA was right to change the rules without a vote. The case was never decided on who was right or wrong. It was simply thrown out on a technicality. The homeowner brought a good fight to the wrong arena.
But here's where the story gets really interesting, because it doesn't just end there. In a pretty unusual move, the judge, at the same time she was throwing the case out, actually gave Mr. Gronlund a detailed roadmap for how he could continue the fight and maybe even win.
She laid out 3 possible paths. First, the political option. Get your neighbors together and elect a totally new HOA board that will actually look out for you. Second, the legal do-over. File a brand new lawsuit, but this time in a different court, a judicial forum that actually does have jurisdiction over both the HOA and the golf course owner. And third, the long-term fix. Go to the state lawmakers and get them to change the law to give this department more power in the future.
And that really brings us to the core lesson of this entire saga, doesn't it? Having the facts on your side, even being on the right side of justice, isn't always enough. You also have to be fighting on the right battleground, in the right court, playing by the right rules.
It all leaves us with a final, really important question to think about. Whether you're dealing with an HOA, your city council, or any other group, understanding the rules of engagement and the limits of their power is just as crucial as knowing your own rights. So, do you know where those lines are drawn in your own community?